Very warm good evening to all. Today we will start with one landmark judgment, that is Arnesh Kumar versus State of Bihar. It is a Supreme Court judgment of 2014. Many of you must be aware of this judgment, but let's discuss this judgment because it is one of the judgment which can be very useful to all the people who are into criminal practice. And otherwise, as a lay person also, we should be aware about this judgment of our land. The reason behind this is one judgment which protects the citizens' right about the arrest. See, whenever a police comes, the first thing happens is like there is a fear in the people and also sometimes in our mind that our clients will be arrested, and we really do not know what will happen. But this is one judgment which will come to handy if you read it, and you will know what are the rights of the accused or the person who is named in the FIR. And there is a possibility that he or she may not be arrested if you know this judgment. Normally nowadays police is aware about this judgment, and they give notice under section 41A, that is of CRPC, a criminal procedure code. It is about the notice of appearance, but sometimes these rules are flouted by the police, and that is where we should, as a lawyer or as a lay person also, as a common citizen of this country, we should know that there is this kind of judgment which protects our rights about the arrest. Now, this judgment is about basically a 498 matter. When it was decided by the Supreme Court, it was about an anticipatory bail, which was rejected by the Session Court and thereafter the High Court. And when the High Court rejected, the matter was appealed to the Supreme Court, the rejected bail application, anticipatory bail application order by way of SLP, that is special leave petition. And when this was brought before the court took the cognizance that it was a simple 498 matter. Dowry Prohibition Acts were also applied. But the court, while deciding the said matter, made some observation which said that there is hardly a 15% conviction. There are many women who are arrested. There are sometimes sister-in-laws who or the old parents are arrested, though they are not residing with the woman, that is the wife who lodges the complaint under 498. But if you see this judgment, it is not only about the 498 matters, it is also about the all the decisions or all the Indian Penal Code offences where the punishment is up to 7 years. That is lesser than 7 months or up to 7 years. Whenever there is a punishment up to 7 years, the Criminal Procedure Code section 41 say that the arrest need not be mandatory. Only in cases where the police feels that the accused or the people named in the FIR should be arrested, they should arrest. Otherwise, they should, and before arresting, they should give a notice, that is under section 41A of CRPC. I would request all of you to read this judgment. It is a very small 8-page judgment. Maybe it will take about 20 minutes or 25 minutes. But you will actually thank me for reading the judgment, because you will be knowing the rights of the accused. And the Supreme Court says that the police is mandatorily has to give a notice under section 41A CRPC to all the people named in the FIR if their punishment is up to 7 years, and there is and they should arrest only when they feel that there is a possibility that the accused may commit repeated crimes, or there is a possibility that he is a hardcore criminal. There are past many FIRs against him. So it is a one section 41A CRPC where notice of appearance before the police is given. It should be given within the 2 weeks after the FIR is lodged. Normally, the police serves the notice, or normally nowadays they are sending by the WhatsApp. But this notice is very mandatory. And if the police do not give this notice under section 41A, it is not, see, always remember, this is not limited to the 498 matters between the husband and wife. This is any offenses, all offenses under Indian Penal Code where the punishment is up to 7 years. So if you know this judgment, you are actually protecting your client, and also you are able to show your knowledge to the client, and they get the impression and also good fees in return. So always remember, you should know this judgment. And the 8 golden rules about the arrest are mentioned in this, and 1 or 2 of them I will mention here. that is in 498 matters. There should not be under these arrests should not be like just casual arrest. It should be there should be some reason if they are arresting. Then 41 notice appearance has to be given. Then failure to do so, police officer is liable to the punishment. If the police officer do not give this notice and straight away arrest the persons named in FIR, he is liable to be under the contempt law. So always remember, this is one advantage where also the judicial officer who will detain the accused, where the punishment is up to 7 years. If without giving a good reasoning or good order that why the accused are arrested and why their detention is necessary, that person, that judicial officer, the judge, the magistrate will also be liable to department inquiry. See, such a powerful judgment. If we know it, it is definitely going to help us. But you should know the contents of this judgment. I will ask Vandana or anybody to put this judgment in the group so you all can read it tonight. Now, next we read the judgment. I will take to the reading segment now. It is one of the important article, one of my favorite from Bar and Bench. Has the Neetu joined? Vandana? This is an article from the Bar and Bench. The 10,000 hour rule never goes out of fashion by Advocate Pallav Mongia. It is one of the very inspiring article, and it will give you what a lawyer actually has to do learning. Is there Neetu to read it? Nidhi, will you read it? Nidhi Kulkarni? Okay, kindly unmute. Unmute yourself. Nidhi, I can't hear you. Nidhi, can you see it? Nidhi, we are unable to hear you. Who is Archana? Can you read it? Okay, I will read it myself. Pallav Mongia, 2009 graduate of the Hidayatullah National Law University, is an advocate on record at the Supreme Court of India. In 2012, Pallav was one of the 2 lawyers who were awarded the litigation fellowship by the Supreme Court Lawyers Welfare Trust. This is in the question answer form. You cleared the AOR exam in the year 2017. What advice do you have for those who are preparing for the exam? Preparing for the AOR exam is an experience in itself. That is advocate on record exam. The syllabus is designed such a manner that one ends up learning a lot. The cases that you read help you revisit the very basics of the constitutional law and of the practice before constitutional courts. At the end of the preparation, you inevitably end up a better lawyer. In terms of advice, I would suggest that you start reading the Supreme Court judgments of the last 2 years. 1 or 2 questions will definitely be related to the latest development. Some senior advocates conduct sessions on the exam a couple of months prior to the date. Make sure to attend this. A lot of examinees, despite knowing the answers, don't end up clearing the exam as they fail to complete their answers given the lengthy nature of exam itself. Start practicing writing fast while ensuring that the writing is legible. It will prove to be crucial. What is it like being a first generation lawyer? Now, this is very important For all of you, those who are feeling that they are why they are first generation, whether they will be successful or not. Now, imagine a scenario where all athletes are ready to at the starting line, but prior to the starting of the race, all athletes whose parents are also athletes are asked to step forward 500 meters and then whistle blows. Litigation as a first generation lawyer is pretty much like that. Second generation lawyers or children of bureaucrats, politicians, and well-connected families will always start a couple of steps ahead of you. Never let that dishearten you, though. For your part, run hard and give it your all. This has worked for me. I believe that while it might be harder, it is not impossible to make it big as a first generation lawyer. It is equal parts daunting and exciting. What impact did Justice J. Sharma Supreme Court Lawyers Welfare Trust Fellowship have on your career? The scholarship was a game changer for me. The nature of the chamber practice is such, especially in the initial years, that you always feel a little lost and keep questioning yourself whether you are on the correct path. Winning the scholarship was the biggest pat on the back for me. It was an affirmation that I was progressing in the right direction. And suddenly, all the extra work that I was taking on felt worth it. Needless to state, the stipend was a great help in those initial days. As an arbitration counsel, do you think the Indian government will take steps against the recent Vodafone arbitration award? I can't comment on what remedy the government of India might pursue in Singapore. In the Indian context, I don't think the government will initiate proceedings against the award because the moment they file objections against the enforcement, they concede to the application of the Arbitration and Conciliation Act 1996. The first hurdle for Vodafone is to establish that the enforcement of the award is under the aegis of the Arbitration and Conciliation Act, as there are judgments wherein it has been held that the awards passed in investment treaty arbitrations are not commercial in nature, making the Arbitration and Conciliation Act inapplicable. Now, this may go a little over to the students, but this is very important what he's talking about arbitration. Therefore, strategically, it may work out better for the government to wait for Vodafone to take the first step. Furthermore, assuming that Vodafone does succeed in establishing the applicability of the Arbitration and Conciliation Act 1996, the government will have a good defense under the head Public Policy of India, as the tax was imposed retrospectively in the exercise of its sovereign power. Alternatively, if the government decides to honor the award, then that would be a policy decision of the government. You have worked in the Chambers of Justice L. Nageshwar Rao when he was a senior counsel and senior counsel Jayan Bhushan. How have these been different from working in a firm like Karanjwala and Company? When you work in a top firm like Karanjwala, you get exposure to big matters from day one, which I was speaking that you should work with some lawyers and senior lawyers who has a lot of cases. So you get an exposure to big matters from day one. The client comes to you with a problem, you discuss and strategize it and then file it before the relevant forum. I was in Miss Ruby Ahuja's team, just observing the way she led the matter was a master class in practicing law. From the time you meet the client to the first hearing in the matter, numerous hurdles arise in the form of difficult legal propositions, dealing with the registries, that is the court office registry means, and timely listing and so on. A good law firm, however, inculcates in you the attitude of never giving up and always finding a way around. This was my first lesson, forms the foundation of my legal practice. This para is very important. On the other hand, the time with the senior advocate teaches you how to reflect on all aspects of a brief and develop the winning arguments. As Mr. Fali Nariman was advised by Mr. C.K. Daptari. Always remember Fali, it is better to spend more time thinking about a case than merely reading the brief. This is all very important piece of advice from the senior advocates. In a chamber practice, one gets a lot of time to deliberate and discuss the brief, and working with the senior counsel efforts you the opportunity to enhance your thinking prowess. I still remember the drives to the court with the Jain sir and late night conferences with HMJ Rao sir. Discussing arguments with them day in and day out was like playing chess against a grandmaster. You lose on most occasions, but are bound to leave the table a better player. Now here, this is again very important. What advice do you have for those who are planning to take up litigation? Now this is for all of you and including me. They say that you are always being watched. So my advice is always put your best foot forward. You never know who is watching you. So you should be always in good white clothes, proper uniform. You never know who is watching you. Most of my clients are those who have seen my work and then come to me for representation. At the end of the day, you must believe that your work speaks for itself. Mr. Nariman starts his book Before Memory Fades by saying that out of blue, you meet people who lend you a helping hand when you need it the most. I have been lucky to meet some of those people. Most of it is hard work, but some of it is most just serendipitous. Have a circle of 3 pure colleagues who share your passion for law. Discuss your matters with them. Help them out, seek their help, reflect with them on bad days. It acts as a great support system. So it means like we should always support our juniors, also our colleagues. Lastly, always remember to find a joint draft well done or a brief well argued, because at the end of the day you are here because you love law and not for anything else. My parting 2 cents would be that 10,000 hour rule never goes out of fashion. Even if you are an introvert like me, work is bound to come if you are good counsel. Focus on honing your skills and being the best version of you. Everything else will fall in place. See, here is speaking 10,000 hour rule never goes out of fashion. Those who reads many books, they know that those who are champions, they actually take out this plan and complete 10,000 hours. So if you complete 10,000 hours of judgment reading, trust me and believe me that you are going to achieve something which is totally unbelievable. So even if we read 1 hour per day, it will be 365 hours. So to complete 10,000 hours, actually it may take 8 years. But if you double it, 2 hours, it may be 4 years something. So I had a master plan in the last internship. I'll ask Vandana to share it. If you really want, at least start. I am not saying that it is very easy to complete 10,000 hours, but at least you can begin. So well begin is half done. So start reading, maybe 1 hour, 2 hour, at least every Sunday 2 hours. This can be done. So this is easiest thing you all can do. And this article is really helpful and really inspiring. It inspires me still now. So next we will go to another. Ashish, I have seen your message now. I'm so sorry. That can I read if no one is. Actually, everybody is interested, but maybe they did not log in properly. So those who are reading, one request, log in the very beginning. You should keep logging from the 8:55. And at least write a message so I will know that you are there in the group, and video should be on. Anyway, no problem. Next, we will be reading one more judgment that is from the Jharkhand High Court. If Ashish is there now, we can read. But you have to keep your video on, Ashish. Ashish Verma, right? Can you unmute yourself, Ashish? You want to read Ashish, right? Ashish, whether your video is unmute? Video host has disabled. You can start the video. Ashish, I can't see you actually. Keep your video on. Your video is not on.
Yes, ma'am. Now I can, yeah.
Okay, I'll share the judgment of the Jharkhand High Court. Can you see the screen?
Yes, ma'am.
Yes. Just a minute. This is a Jharkhand High Court judgment. See, in High Court, there are different kind of matters. This is one of the very different kind of matters I wanted to share with you. Conclusion of departmental proceedings on the ground of conviction by trial court. Will subsequent acquittal by High Court affect the outcome of the departmental proceedings? Ashish, you can start from here now. Please start. Hello. Please unmute.
Yes, ma'am. Yes, ma'am.
Just a minute. Start from yes.
Yeah. So, Jharkhand High Court, Sanjay Kumar Dwivedi, while
Slowly.
holding the reason assigned by the Director General of Police, while rejecting the claim of the petitioner to review the order of his suspension, bad in law, directed the DGP to reconsider the matter. The petitioner had preferred.
More slow, because people are reading it
Okay.
first time, right?
Okay, sure, ma'am. So the petitioner had preferred this writ petition for questioning the order of the DGP, Government of Jharkhand, whereby the revision application preferred against the order passed by the Inspector General of Police had been affirmed. The petitioner, a sub-inspector, was alleged to have shot his wife and was charged with offense
Continue.
and was charged with and was charged with offences under section 302 of IPC 1860 and section 27 of the Arms Act 1959, pursuant to which the petitioner was suspended from the service and a show cause notice was issued. Meanwhile, the trial court convicted and sentenced the petitioner to undergo life imprisonment in the said case, and accordingly, the inquiry report was submitted in the departmental proceeding. Next, the petitioner assailed the impeached order on the ground that in the departmental proceeding, inquiry report was submitted only on the ground that the petitioner had been convicted by the trial court and without adducing any evidence in the departmental proceeding. The inquiry report was submitted without giving him any opportunity.
Hence, the same was.
Hence, the same was against the principle of natural justice. Moreover, the petitioner was acquitted by the High Court in an appeal against the judgment of the trial court. On the contrary, the state argued that the departmental proceedings and criminal proceeding are two different subjects and parameters of both the proceedings are different, merely on the ground that the petitioner had been acquitted in the criminal case by the High Court and case of the petitioner could not be considered for reinstatement. Noticeably, when the inquiry report was submitted in the departmental proceeding, the petitioner was being treated in Rashi Institute of Neuropsychiatry and Allied Sciences for mental illness, which was via reply to the show cause had not been received. Considering the stand taken by the state that the DGP had rejected the revision applications of the petitioner after acquittal by the High Court, on the ground that the High Court had not directed for reinstatement of the petitioner in service while acquitting the petitioner, the bench stated that it is well known that the High Court, while acquitting the petitioner, has decided the criminal case only, and the authority concerned has to consider the reinstatement of the petitioner in service while passing a reasoned order. So, from the inquiry report, it is transpired that the petitioner was being treated in RINPAS, and the inquiry report had been submitted only taking into consideration the petitioner had been convicted by the trial court. Hence, the bench held that the reason assigned by the DGP while rejecting the claim of the petitioner did not sound good. So, in the light of the above, the impeachment order was quashed and the matter was remitted to the DGP to consider the case of the petitioner afresh and pass a reasoned order. So, this is the Anand Kumar Singh versus State of Jharkhand.
Very nice. Thank you. Thank you for coming to the last minute rescue. Thanks.
Thank you, ma'am.
Well done. Now, this was a judgment from the Jharkhand High Court, and the blog was it was a SCC. So if you go through the SCC, you will find small judgments. It may be on anticipatory bail, it may be on the rape matters, it may be on writ petitions. So I would request all of you to read it whenever possible. And it is not that it will take a lot of your time. How much time the Ashish took, same time we are going to take. But this will actually refresh your knowledge about the legal words. Now, I will try to share it again. So I will point out some good words from the same. Now here you see. There are, I will put parameters. See, the word parameters, subject and parameters of both the proceedings. Then there is a word adducing any evidence produced karna. Then there is a law of natural justice. See, these are the legal words you should use in your drafting, and this will come in your drafting only when you will continue to some Archana, mute yourself. There is a voice coming from your side. I would request all of you to mute yourself. So whenever you are reading any judgments, you are going to repeat those words, legal words. Now, adducing evidence. See, producing evidence, adducing evidence are totally different things. But when you use good words, that I have, the petitioner has adduced evidence, it actually makes a difference. So these are the good words you should be able to use, but this will come up only when you will keep on reading the judgments. We go to another segment, that is a little learning. Section 411 of the Indian Penal Code and section 412 of the Indian Penal Code. Now these are two different sections, and they are rarely used, but they are used when there is a stolen property which is purchased or maybe unknowingly or knowingly purchased by the another person who is also accused in the affair. If you by chance you are buying a stolen property and it is in your knowledge that this property is stolen, if you are receiver of the stolen property, you can be charged under Indian Penal Code. That is 411 and 412 of the Indian Penal Code. Now these are different sections. Now what is the difference between 411 and 412? Let's go to definition. Now see the 411 definition. Dishonestly receiving stolen property. Whoever dishonestly receives or retains any stolen property, knowing or having reason to believe the same to be stolen property, shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine or with both. See, it is simple. Whoever dishonestly receives or retains any stolen property. Now there is a possibility that somebody comes to your door and say, this is a cell phone, are you ready to buy? And we know that this cell phone is we are buying from unknown person. Now when we are buying from unknown person, you should be careful, because it may be a Apple phone which is costing 40,000 and somebody selling in 10,000, and there is no bill of the same, and you are not buying from authorized person. Then you should know that this is the something wrong. So you should know that it may be stolen property. Somebody selling it a lesser price. See, at the trial, you may be able to prove your innocence, but there is a possibility that your name will, there may be an FIR. Or there are jewelers who buys the gold from unknown people. And later on, when the police comes, they have to give all this gold. And if it is, they know that police find out in the Panchanama, they knew that it is stolen property, stolen gold from somebody's house because of dacoity, then they will also be named in FIR. Now we go to section 412 of the Indian Penal Code. Almost same, but there is a small difference. Dishonestly receiving property stolen in the commission of dacoity. Now see, 412. The word used is dacoity here. Whoever dishonestly receives or retains any stolen property, the possession whereof he knows or has reason to believe to have been transferred by the commission of the dacoity or dishonesty receives from a person whom he knows has reason to believe to belong or to have belonged to a gang of dacoits, property which he knows or has reason to believe to have been stolen shall be punished with imprisonment for or life. See, there the punishment is just 3 years or with fine or with both. But here the see the difference is like a sea change difference here. Shall be for punish shall be punished with imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. So the difference is very small, but the punishment is very bigger. Now, if you do not know the difference, it will be really difficult for you to defend. If it is your client is only charged for 411, it's a almost 3 years punishment. So you can say he this is stolen property. It was the punishment is up to 3 years, triable by magistrate court. But if it is a dacoity, then it may be triable by the session court if the charges or charge sheet is committed later on. So always remember that whenever you want to see the charges, whenever the FIR comes to you, first go and see what are the charges. And if you do not know the charges and what is the punishment for that, you may not be able to differentiate whether the case will be triable by the magistrate court or the session court. Number two, what is the punishment? Here, 411 and 412, there is only one number difference, but one is 3 years, one is up to life imprisonment, and that also rigorous punishment. So you should be knowing this, that there is a possibility that your client may not be having the knowledge that this is a stolen property. So we should be always careful whenever we are buying gold or any property from an unknown person. As a jeweler also, they have to take care. As a businessman also, we have to take care. As a professional also, as a the common citizen also, whenever we are buying a property, if somebody is giving it a throwaway price, we should be very careful if it is unauthorizedly sold. So always buy from authorized person, because this kind of matters happens in jewelry or something, mostly mobile cell phones, or in car theft also it happens. So this is all about today. Anybody has any questions? We can have gallery view. You can unmute yourself. Sumay's question is there, what is a show cause notice? Now in what context you're talking?
Hey, it is not about the this one color and same color same. Who's pink?
Okay, no question for today. Thank you. Thank you so much.
Hello, ma'am.
Yes,
Madam, good evening, ma'am.
good evening.
Ma'am, advocate Ranpise.
हाँ,
Just
बोलो sir, बोलो.
madam, regarding whatever your ethics, you have ethics or other discipline, or we can say the guidelines given for the good practice